Hi, and welcome to Is That Even Constitutional? This is a podcast where we use the lens of the Constitution to talk about some current events. And my name is Sadhana Devaraja, and I'm not a constitutional scholar, but lucky for me, my good friend Ken Thomas is. How are you, Ken?
Doing great, Sadhana. How are you?
I am doing well. I'm excited because, in this second season, which we're calling the Project 2026 series, we're taking an angle of putting forth 10 winnable proposals that helps us reclaim the Constitution through legislation. And now we're on the 9th proposal of that arc. So far we've covered ending the filibuster, ending gerrymandering, making Election Day a national holiday, setting term limits for the Supreme Court, ending the Electoral College, making D.C. a state, working on the right to plan your family, limiting corporate speech, and today we're going to be talking about stopping the negligent sale of firearms. So last time when we were talking about limiting corporate speech, I mentioned that probably one of the most popularly cited parts of the Constitution is probably the right to free speech. And if that's one of them, then another one certainly is the right to bear arms. I think similarly, whether people are citing it exactly right or not is another issue, but it's probably one of a handful of parts of the Constitution that Americans recognize to be in there. And so maybe we'll just start off by talking about how bad is gun violence in the United States. Can you walk us through that, Ken?
Sure, Sadhana. So the numbers for gun violence in the United States are really at some of the worst levels we've ever seen them. The Center for Disease Control estimates that over 47,000 people die of gun injuries every year. And this is some of the highest totals on records. The Gun Violence Archive, which tracks shootings and murders, indicate that there have been 722 victims of mass shootings in the United States. And this is from statistics from 2023. And what's probably the worst part about this is that these deaths are something that are clearly avoidable. Firearm homicide rates in the United States are much, much higher than in many other countries, certainly the kind of countries we normally associate ourselves with, such as European countries. And so, for instance, it turns out that if you are a person living in France, then you are 19 times less likely to be shot than an American. And if you are somebody in Germany, you're 77 times less likely to be shot than you would be as if you were living in America. So clearly, our homicide rate may be a variety of factors, but one obvious factor that we do have is that we have access to guns in the United States, and this access to guns is associated with a lot of gun deaths and a lot of gun injuries.
Yeah, and some of the countries you mentioned have significant gun regulations. I'm curious, how does it play out in their constitutions and the regulations around gun ownership?
Well, it turns out that the Second Amendment, like some other things in the Constitution we've talked about, is actually an extreme outlier in the international community. Almost nobody addresses gun ownership in their constitutions, and a couple of countries that do not have rights that preclude very extensive gun regulation. So you can really safely say that no other country has a Second Amendment like ours. Ours, at this point, is been interpreted to allow almost unrestricted gun use. And what people may not remember is that this is relatively new. For over 2 centuries, the Supreme Court did not find that gun regulation was something that was of a extreme constitutional concern. So how did this come about? Well, if we read the Second Amendment, it says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, even to a layman, this sounds like we're talking about state militias and the ability of people to defend themselves, and not necessarily individuals' rights to have guns to be used against anybody that they feel like it. And so And that's actually what the Supreme Court believed too. So for many years, the Supreme Court held that the right to bear arms was a right that was essentially a right of the states, the right of the states to have guns for their state militias. And this all changed in 2008. That was the year that we had the District of Columbia versus Heller decision. And that was where the Supreme Court held that for the first time that individuals had a right to bear arms. Now, what this right wasn't clear at the beginning. The Heller case was more a case having to do with people protecting their homes, and it was whether or not there could be a gun law which prevented people from bearing arms in their homes, from essentially keeping arms to protect themselves. That was the DC versus Heller case. Then we had to wait until 2022 to get a idea of what the Supreme Court was going to do with this. And so that case that was decided was New York Rifle and Pistol Association versus Bruin. And this extended the right to carry firearms outside the house. Now, the Bruin case also added a new analysis to how Second Amendment rights would be interpreted, and that was going to be the analysis of the history of gun regulation. And essentially what the court held, and this is under a doctrine known as originalism, was that if the founding fathers did not restrict gun ownership during the era that the Constitution was drafted, then this would basically be folded into the Second Amendment. And so if there are not historical examples of gun regulation, then there can't be modern examples. Kind of a rather dramatic way to use history to inform what the founding fathers thought at the time. A lot of people certainly disagreed with this interpretation, but that's where we are right now. So what this means that really almost any gun regulation is in play, and in order to figure out whether or not a gun restriction is constitutional, you have to do a historical analysis. And so, for instance, the Fifth Circuit in a case called U.S. versus Daniel was considering whether or not drug addicts who have for many years now not been allowed to own firearms were historically deprived of firearms at the time of the Constitution. And the answer was that no, we didn't have a lot of regulations of that back then, so that was struck down. And then the Third Circuit in the United States Court of Appeals for the Third Circuit, in a case called Range versus Attorney General, struck down limitations on felons being able to own firearms. In this particular case, the person who was suing was a non-violent felon. Their crime had not been violent, but the court essentially found that because there was no real indication that the founding fathers had been aware of that kind of regulation, that it was not something that was going to be allowed. So we really don't even know where this kind of case law is going to end. And the irony here is that as we have this surging series of court cases limiting gun rights, we find that most Americans are deeply, deeply interested in gun regulations. As a matter of fact, 70% of Americans are interested in there being some level of gun regulation. And this is obviously because what we spoke about before, which is that obviously the ownership of guns has really meant that there is a lot of gun violence in this country.
Yeah, this is wild to me because so just to kind of recap some of what I heard here, on its face, the Second Amendment sounds like it's related to a state militia rather than an individual right. And it's pretty recent for that right to bear arms to be considered an individual right through the Heller decision in 2008, which is like in our lifetimes here. And then there are a series of cases that are kind of following this line of thinking that if there weren't historical gun regulations at the time of the Second Amendment, then there can't be modern ones. And you walk through a couple of them where people with substance use or convicted of felonies weren't historically limited. And so there might not be limitations now. I mean, I think that's wild because the guns nowadays are not the guns of that time either. And so following that kind of logic doesn't feel very logical. And that might be why, as you're saying, 70% of Americans want stricter gun regulations. They're probably feeling that change in the type of guns and the impacts that it has on our society now. So if that's all right, then what kind of regulations might be constitutional?
Well, that's really a question that we don't know the answer to. So, for instance, one law that federal law that was in place for a number of years, is no longer in case, was a ban on assault weapons. So the idea being is that, again, maybe you can make the historical argument, well, we didn't have weapons at the time of the founding fathers that could shoot many, many rounds of guns without any type of trigger movement or any kind of reloading. And so, one might argue that the assault gun ban would be constitutional, but we really don't know. The federal courts have actually considered this, and they've been split on it so far, and the Supreme Court has not addressed this. And so we really are still kind of struggling to figure out what kind of criminal law gun regulations there can be. However, this does leave another type of regulation, gun regulation, that interestingly enough was legal for really many years and was only struck down not by the Supreme Court, but interestingly enough by the Congress. And so that is the idea of going after gun sellers and gun manufacturers for negligence regarding their guns. Now, obviously, this negligence could include something like the guns themselves are dangerous because they are, manufactured incorrectly, or they don't shoot correctly, or somebody gets harmed. But there's also a concept in tort law of negligent sale. The idea being is that if you sell somebody a gun and you either know or have reason to know that that person is likely to commit a crime, then there is basically a historical precedent for holding these sellers and manufacturers criminally, civilly liable for this. And civil liability could obviously be a lot of money, especially if somebody's been killed. And what's interesting about this idea is that the Alcohol and Tobacco and Firearm Agency shows that it's actually a relatively small percentage of licensed gun dealers who are responsible for selling guns that end up in the hands of criminals. Often the gun sales are not directly to the criminals. They are through straw man purchases. And this is where somebody who is legally allowed to own the gun or who has no particular interest in using that gun in a crime purchases the gun and then immediately sells it to people who are involved in criminal activity. And so these straw man purchases, first of all, put a evidentiary distance between the gun sale and the person who ultimately uses it. Might be hard to track that person. But then secondly, it bypasses background checks and record keeping that legal gun sales are associated with. And so civil suits against gun manufacturers is something that could also be considered in kind of gun regulations.
Okay, so it sounds like there's kind of where we started was talking about the modernity of the guns versus at the time of the Second Amendment, and there's still a split on kind of the constitutionality of an assault rifle ban, and the courts are split on it. The Supreme Court hasn't taken up those cases, but there may be other laws that can curb some of what we're seeing in terms of avoidable gun deaths. So those that kind of target gun manufacturers and dealers, which I heard right now is a small percentage in terms of like the ones that are responsible for a sale, to people that are using them illegally. So maybe the majority of licensed gun dealers wouldn't be affected by this regulation because they're doing it in a way that isn't getting guns into the hands of people that are using them to create harm. And then there's also maybe like civil laws that might be applicable here. So dealing with kind of negligent sales might be one of the ways that we can get to regulate guns in a constitutional manner. So I wonder, if there are these civil laws that might be constitutional, are there successful civil cases that have been brought as a result of shooting incidents?
That's a great question. So we did have a number of cases where gun manufacturers were held liable for negligence. And one of the more extreme examples was there's a gun manufacturer called Daniel Defense, and they were sued because they were not only selling, this particular type of gun. They're essentially assault rifles. They're very similar to the AR-15, but they were advertising to people who were too young to buy them. So for instance, if you know anything about military video games, there's one called Call of Duty. Over 500 million copies of that game have been sold, and it turns out that 60% of U.S. teenagers have played this game. Daniel Defense decided that it would be a good idea to advertise in the Call of Duty video game. It would be an advertisement that would come up when the game was loading for their guns. And these advertisements were going to be going in some very, very large numbers to people who were too young to be buying the gun. And so the Daniel defense was sued, and there are a number of different lawsuits. Some were settled and some were ongoing that involved whether or not they should be held liable for gun deaths. And so was a particular note here was that the Daniel defense guns were used in two specific mass shootings. One was a elementary school in Uvalde, Texas, where 19 children and 2 teachers were killed. And I'm sure you remember the Las Vegas concert where 60 people were killed by a sniper shooting down into a concert. And that, again, was a Daniel defense weapon that was used. And so consequently, that was the basis for litigation. And that was the basis where these kind of cases were being brought up to a certain point. And then, of course, what happened is that Congress stepped in and essentially passed a statute relevant to this case law.
So repeal of the federal law is what would enable us to allow gun violence victims to sue for the negligent sale of these items. Is that right, Ken?
This is something that Congress clearly can do something about. As I said, the Congress passed a law. It was actually a law called Protection of Lawful Commerce in Arms Act. This was passed in 2005, signed by President Bush. And this is the law that at this point is stopping those negligent gun suits from being brought forward. Lawsuits actually were very similar to the kind of lawsuits that have been brought against car manufacturers, pharmaceutical producers of opioids, tobacco. These are the kind of suits that actually have had big impacts on certain industries that are dealing in dangerous sales, essentially. And this is something that Congress could address. There have been calls for repeal of this law. And if there was a repeal of this law, then this would essentially open up the possibility of some very serious concerns in the manufacturers and sellers in who they sell the guns to. And this really could have a big impact on using guns in crimes.
Wow. Okay. So, well, thanks for walking us through that, Ken. It sounds like I've had to summarize some of what we heard. You know, the Second Amendment is somewhat of a unique feature. Most constitutions internationally don't have a right to bear arms within them. On its face, it reads as a right to a state militia to bear arms, but we've had a Supreme Court ruling that says it applies to individuals. Since then, the regulations have been a little bit contorted in that we're following a path where if there hadn't been historic gun regulations at the time of the Second Amendment addressing certain populations of people who are accessing guns, for example, then there can't be modern ones. And then there's also some other routes that we're just not sure about in terms of regulating gun use or gun sales, I would say. So there's some criminal gun regulations. We don't really know if bans on a whole class of guns will be constitutional or not. We see some civil law regulation of guns in terms of whether there's negligent sales. What we do know, though, are two things, I think. One is that most Americans, 70% of Americans, want there to be more gun regulations, and that we do know that a small percentage of the sellers are kind of engaging in these sales that are harmful in terms of selling to people with kind of criminal usage. So thanks, folks, for listening in. You know, this is the 9th proposal that we've had. This is the one where we think there's a path forward, it's popular, and there is a viable future to protect, that original likely intent of the Second Amendment a little bit further through legislation. Thanks, folks, for listening. We're looking forward to digging in on the last one with you all next time. Feel free to get in touch with us, give us your feedback, leave comments, subscribe. And if you want to talk to us about these proposals further, you can always email us at production@constitutionpod.com. Thanks, Ken.
Thanks, Adna.